Sarah Boone's attorneys have been filing motion after motion on her case as the trial date of October 7th is quickly approaching. And as the judge has already said, that date is not going to get moved, barring some crazy fluke emergency. This trial is going to happen October 7th, 2024. So the defense have been filing a number of different motions in this case. The last motion that we broke down and explained and researched was the motion to suppress the 2-hour interrogation of Sarah Boone. And that interrogation, like we've explained, is a real problem for Sarah Boone because they're trying to change the defense now to be that she actually acted intentionally as in the course of self-defense because she was a battered spouse and she was suffering for so many years in domestic violence that she really did that intentionally because her life was in imminent danger. All right. So that's going to really be a problem because in her interrogation, she's repeatedly said that this was one big accident and that she never intended it. And she just went to sleep and they were great that day. They didn't get into it. No one was upset at each other. No one hit each other. Everything was great. So how are these two going to live in the same courtroom? Well, that's the problem. So therefore, they filed a motion to suppress that video. Now, we already broke down that motion and that response, and we went through the case law that has to do with Miranda rights. When does Miranda trigger, and whether something was considered coerced or not, a statement was coerced or involuntary. We explained that all in our last videos. Go check that out if you haven't yet. That will really give you a good understanding of Miranda in general and as it relates to this specific motion. So now let's move on to the next motion. This next motion is a motion by the defense for Sarah Boone that she should be able to have a number of different services available for her, really services available for her as she is going through this trial. So number one, she wants that she should be able to appear in civilian clothing. Number two, she doesn't want to have to get handcuffs. She wants her handcuffs off. Number three is she wants a professional hairstylist. And number four, she wants her makeup done. All right, so those are the things that she's asking for. Now, this is not just one general category. The way that this works is that you have to analyze each of the requests under the relevant case law. So in this situation, you look to Florida case law, and we'll see what the courts have to say about each individual request. Because again, you don't just look at this broadly. Do we care generally about the appearance of a defendant in a trial? And then say, well, once we care, so then who knows? Yeah, maybe we do allow a professional hairstylist and or someone to do her makeup. Maybe that all is all lumped under one big category. That's not the way it works. Each individual request has to be analyzed under the case law. So that's exactly what we're going to be doing. Let's look at the motion. It's a very short motion. And this time, actually, they did cite some case law, which is already an improvement that we're seeing. So that's good. But we'll see whether they're eventually the conclusion from all the cases support what the request is. All right, so let's take a look. Here we go. Defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. Statement of facts. Defendant is presently incarcerated and is scheduled for trial on October 7th, 2024. Yep, that we all know. Number two, defendant has been incarcerated for over 4 years. Now, why are they throwing in that fact? Is this just to get some sympathy from the judge? Is this a sob story? Look, she's been incarcerated for 4 years. Let's have a little bit of pity on her and let her have her hair done at least during the trial. No. The reason why they're mentioning that fact, I believe, is that every single day in prison that you spend in prison and jail has an effect on your physical appearance. It just does. The longer you've been in jail, the longer it looks like you've been in jail. So they're saying, look, she's been in jail for a long time. She really could use some help with her physical appearance. All right. And the defense would like access to professional hairstyling, cosmetics, and civilian clothing without restraints throughout defendant's trial appearance. Now, why is that? Why are you asking for these 4 requests? And this is the reason that they give. In respect for the court and prospective jurors. So why do we want this? This is not because I want to look good. This is just out of respect for the court and the proceedings and respect for the prospective jurors. Now, we're going to see that actually that has no basis in the law. The law does not care exactly about your hair and your civilian clothing in terms of your respect that you're showing for the court or your respect for prospective jurors. Now, this to me looks like more of a layman's reason. Someone who doesn't understand how the motions are filed and understand how you have to argue your motions. because there's no basis in the law for this. We're going to see this motion. There's no basis for this. So I don't know. Again, the attorney was the one who put his name on this. So if you're going to say that Sarah Boone was really the one who asked for this and wrote it, still the attorney is putting their name to this. And therefore, when you cite a reason out of respect for the court and prospective jurors, and there's no case or rule that says that out of respect for the court, we allow defendants to wear these type of things, and they don't cite any sort of cases that have anything to do with respect for the court, then it's just a losing argument. So I don't really love the way that they gave a reason here, which has no basis in the law. Now, there is some arguments that they're going to make, which are good arguments, but this one you just don't find anywhere. So I think this was just a big mistake. All right, let's continue. Without the court entering an order permitting her access to such, the right to receive a fair trial will be impermissibly infringed upon. All right, now we're talking. Now we're getting somewhere. Once you say the word fair and fair trial, now that's going to start to trigger some of your rights. Right? So again, without the court entering an order permitting her access to such, these four requests, the right to receive a fair trial will be impermissibly infringed upon. Now, what's the idea of a fair trial? Where do we have a right to have a fair and impartial trial? Well, this is found in the 14th Amendment. The 14th Amendment, that's the amendment which gives everyone, a defendant, due process. So part of due process means that you have a fair and impartial trial. Now, what's interesting is that we're about to get into the presumption of innocence. What's interesting is actually that the presumption of innocence, this that we keep hearing about, everyone is presumed innocent. You would think that that's actually some sort of clause in the Constitution. And the answer is that that's actually not. The reality is it's not. There's no clause that says that every defendant enjoys a presumption of innocence. But all the cases, all the courts have said that although the presumption of innocence is not specifically mentioned in the Constitution, but it is still recognized as a component of due process. So it's really embodied in the 14th Amendment. The due process clause, embodied in that is also that there is a presumption of innocence. Okay, so now we're actually getting somewhere which matters. The presumption of innocence is a basic component of the fundamental right to a fair trial. That's right. Since the defendant pending and during his trial is still presumed innocent, which that's true, he is entitled to be brought before the court with the appearance, dignity, and self-respect of a free and innocent man, except as the necessary safety and decorum of the court may otherwise require. He is therefore entitled to wear civilian clothes rather than prison clothing at his trial. So here you have a direct quote from a case in Florida which says a defendant is entitled to wear civilian clothing. Now, there can be an argument already made from this exact quote that, again, it says the appearance, he should be able to be brought before the court with the appearance, dignity, and self-respect of a free and innocent man. Now, you can make an argument that they didn't. I think they should have if they would have asked or consulted with brother counsel. I think that they could have made an argument that it's not just about how I appear to the jury, but it's also my own dignity, my own self-respect. I need to feel like I'm a free and innocent person. I'll be a better advocate for myself. I'll be able to help my attorneys more if I have some self-respect for myself, if I have some dignity for myself. It's not just about the jury. That could be definitely an argument that was made here, but they didn't ask me, so they didn't make this argument. So here, again, they're just quoting this as showing a right to appear in civilian clothing. And yeah, definitely, this case definitely says very clearly that they have a right to wear civilian clothing. But again, the whole point of this motion is that they're going to try to make the jump that not only should she be allowed to wear civilian clothing, but that also she should be able to have her hair done professionally and that she should be able to have access to makeup. So an argument for dignity and self-respect is much more of a stronger argument for that than what I think they're actually going to make. Well, let's continue. Here, defendant is scheduled for trial on October 7th, 2024. The defendant will be transported from the Orange County Jail daily for her trial proceedings. Defense counsel will be providing the defendant with professional attire for the court appearance. So defense counsel already knows that the judge is going to allow her to wear civilian clothing. That's always happens, basically. So defense counsel already knows this, and the defense counsel is ready to provide her with professional attire. In addition, the defense will need to obtain defendant's measurements. Now, sometimes, no, you can't get the measurements because You basically know, large, medium, small. Use your imagination that get something that she's going to be able to wear. But they want her to look perfect. They want her measurements. Therefore, defendant requests this court to enter an order placing the Orange County Jail on notice that, number one, the defense is permitted to take defendant's measurements. Now, to just put on a pair of jeans and a nice shirt, or even not a pair of jeans, some nice pants or a nice skirt, you don't need the exact measurements. You don't need to get tailored to your specific measurements. But this is what they're asking for anyway. And defendant is permitted to dress out in her civilian clothes for her trial proceedings from October 7th, 2024 through October 25th, 2024. All right, so this is just a request for civilian clothing. And okay, they're pushing a little bit, asking to get her measurements. This is going to get granted. She is going to be allowed to wear civilian clothing. All right, continue. Right to appear without physical restraints. Allowing a defendant to appear before the jury in restraint devices is an inherently prejudicial practice that undermines the presumption of innocence and the right to a fair trial. Well, there you go. If it undermines the presumption of innocence and the right to a fair trial, which is all the 14th Amendment, so then you got a problem. You can't allow the defendant to appear with physical restraints. Generally, a defendant in a criminal trial has the right to appear before the jury free from physical restraints, such as shackles or handcuffs. So generally, and that's a very important word there, generally that's true. There are certain times where a defendant is required to be shackled or handcuffed. Now, of course, if they're going to be handcuffed, then they can do it in a way that's inconspicuous, but there are times where you are allowed to handcuff someone. So, for example, if the person has a history of trying to escape, if he tried to escape from jail, or while he's being transported. So then, obviously, you're going to be allowed to shackle them or handcuff them. Or if, let's say, they're going to cause a big disturbance, or if there's potential injury, they're very violent people. It's a very violent defendant, and they have a history of being violent in jail, or a history generally, a criminal history of being violent. So that also may be a good reason for her to have handcuffs on her. Now, if some of you have been following this already, then you know that there was already a motion and hearing about this specific issue about handcuffs. And the judge already ordered that she's going to be allowed to wear some sort of ankle bracelet, which it's a stun cuff, which has some sort of electrical, that she can get shocked with it if she tries to run away. So the judge already ordered that. So really they know that the handcuffs here is just going to be some sort of ankle bracelet or leg bracelet. All right, but anyway, continuing. On September 19th, 2024, defendant appeared in court bearing handcuffs and shackles. Defendant's hand restraints made it difficult for her to communicate with counsel in written note-taking form. In addition, it is reasonable to assume that the next court hearings will be covered by local and national media. Yep, that's certainly reasonable to assume. And if defendant is put on display to prospective jurors in jail garb, and again, these are prospective jurors who haven't seen Sarah Boone for the past 4 years in all of her hearings. All right. They will naturally be led to doubt in her presumption of innocence. So therefore, even before the trial, they're asking that she should be allowed to not wear handcuffs, presumably also not wear jail garb. Therefore, defendant is requesting that the hand restraints be removed at all court proceedings from here on out, and that both shackles and handcuffs be removed during trial proceedings. Well, they're also asking that she should not be wearing jail garb, because if you're trying to protect the prospective jurors from thinking that she's already guilty, well, then you should also be essentially asking that she should be appearing at any future hearings in civilian clothing. Okay, that's most likely not going to get granted. All right, let's move on. Right to control appearance in the courtroom and before the jury. The courts have recognized that a defendant's appearance can significantly impact the jury's perception and consequently the fairness of the trial. That's right. That's what we've been talking about up until now. Every single line has been talking about the fairness of trial. In Estelle versus Williams, the United States Supreme Court noted that compelling a defendant to stand trial in prison or jail clothing could impair the presumption of innocence. Have you ever heard that before? Have you ever heard this before until this part of the motion, until this part of the brief, that a defendant standing trial in prison or jail clothing could impair the presumption of innocence? Have you heard that before? Of course you have. We've been hearing up on this entire motion has been about that specific issue, that impairs the presumption of innocence, which is fundamental to the adversary system. So something that just irks me a little bit about this brief writing is that if you're going to state a proposition, and it's a very, very well-known and well-recognized conclusion, then what you should do is you should say it once, in the beginning of your brief or when you're talking about it. And then when you say that, you say, and this conclusion, this preposition has been found to be the conclusion of a number of different courts in a number of different jurisdictions. For example, we have Florida. For example, we have the federal circuit. We have the United States Supreme Court. Just take care of it all in one area. And then you can always refer back to it and say, as we've already said, the appearance, defendant's appearance can significantly impact the jury's perception. And it can be the presumption of innocence, and talk about that like we've already discussed. But here, it's like they already mentioned it once. Now they're going to bring it again from the United States Supreme Court. It's the same exact thing. All right, but anyway, allowing the defendant to present herself in a manner that does not unduly prejudice the jury is essential to ensuring her right to a fair trial and upholding the presumption of innocence. Okay, yes, we've heard that. And while the court in Estelle, now here we go, because this is really what it comes down to. This next few lines is what this motion really comes down to. Because as we said already, the civilian clothing she's going to be allowed to wear. The shackles, the handcuffs, she's not going to be handcuffed. She's going to have that one stun cuff on her leg. So it's really about the hair and the makeup. So what argument can they possibly make for the hair and the makeup? Well, if they would have listened to Brother Counsel, I already told you what a better argument was going to be. But here, let's see what their argument is. And while the court in Estelle specifically addressed prison attire, the underlying principle applies broadly to any aspect of a defendant's appearance that could influence the jury's perception. Okay, stop. The court in Estelle was talking about prison attire. What's the problem with wearing prison attire? The problem with wearing prison attire is that it takes away the presumption of innocence. And therefore, you don't have a fair trial. If the jury's thinking that she's already guilty, you don't have a fair trial. That's what it comes down to. But now they're trying to broadly apply it to any aspect of a defendant's appearance that could influence the jury's perception. No, that could influence the jury's perception about what? About what? The only issue here is, can it influence the jury's perception about her presumption of innocence? That's what it comes down to. Not just her perception as, if she'd look a lot nicer in makeup. That's not, they don't care about whether the jury wants to vote her as the top 10 most beautiful women in the world. That's not the issue. The issue is, does this take away her presumption of innocence? So that's the only question. All right, but anyway, continuing. Defendant has a right to appear before this court and prospective jurors in the same manner as she would outside of confinement. Any case law for that? No, it all comes down to that she has a right to appear before the prospective jurors in a way that's fair. They don't automatically assume that she's guilty, as she's neutral. Not that they're wowed by her appearance, not that they're thinking about, I wonder who that hairdresser is because I want to go and make an appointment with her after the trial. That's not the issue. All right, but anyway, cosmetics and hairstyling is standard practice in presenting a professional appearance if the individual so chooses. Now, that's true, right? When you have a professional meeting or a business meeting, then yeah, you may do your hair and you may put on some makeup. But what does it have to do with the ultimate issue here, which is, do you have the presumption of innocence or not? By extension. So now here we go. Now, by extension, incarcerated males are permitted a fresh shave and haircut. So when a male is being tried, he's the defendant, he is allowed to shave and also take a haircut. Accordingly, the defendant requests that she be permitted access to cosmetics and hair styling throughout her trial proceedings, including voir dire. Now, do you think there's any difference between hair styling and haircut? Can anybody think of any difference between that? Yeah, because if you're in jail for 3 years and your hair grew out and you look completely disheveled and you have a big beard and you can't shave and you look like you've been incarcerated, that's exactly what you look like. It's essentially wearing prison garb. So therefore, we allow a male to shave and take a haircut. Now, if she doesn't look like that, if her hair is well kept, if it looks like she's had a recent haircut at some point, or it doesn't look like she's been sitting in jail for the past 3 months, well, then it's not the greatest comparison. So again, this is really what it all comes down to, that they're trying to get this professional hairstylist and the makeup done. And like I said, this is not really the strongest argument. I think a better argument, like we said in the beginning, was this issue right here. It was Atkins versus State. It's a Florida case, and it says here, he is entitled to be brought before the court with the appearance, dignity, and self-respect of a free an innocent man. That's where the argument could have been made. Again, it would have lost, but still, I think a stronger argument that I need to have my dignity. I'm going on trial now for my life. I may be sitting, I need to have my dignity. It's going to change the way that I approach the proceedings. I'm going to be much more serious about it. I'm going to be able to help out my attorneys more. I'm going to be able to just feel a little bit more better about the situation. So then maybe that would be an argument. But again, like the arguments that they made, I don't think are that great. And like we can, if you're a betting man and you already took me up on my last bet, which I told you the motion to suppress is going to get denied, then you can also certainly guarantee that this motion for a professional hairstylist and makeup is also going to get denied. And we'll be able to move forward with the trial on October 7th. So that is going to be it for today. Please, if you haven't yet, please subscribe and like, and we will see you next time.